Morning, Mr. Raman, how are you?
I'm good, how are you?
I'm good. You're speaking to Naomi. I've spoken to you several times last year about my case with the Master of High Court.
Yeah.
And I am appealing to you now to report this matter or tell me how to do it, because I want the Justice Portfolio Committee to call the people involved in my matter for them to tell the truth. Because now I am tired. I've waited, I've tried everything. Nobody seems to want to do anything.
Can you do this, because I'm preparing for a meeting now in at 9:30 with the master's office. Can we talk afterward?
Pardon?
Can you talk afterward, because I'm preparing for a meeting now at 9:30?
Yes, please, if you are meeting with the master, you must also just ask them what is going on with my name.
No.
Please.
Okay, but I will talk to the chair, but we've got other matters that we'll discuss, but I'll talk to the chair.
Yes, because nobody wants to do anything, and this is so bad.
Okay.
Me, I want this letter to go to Parliament, and that's how I got involved with you to say, please take this letter to Parliament, and you try to mediate. Nothing is happening, so I think it's high time that it must go there now.
Okay.
Thank you.
Okay.
I'll hear from you.
Okay.
Thank you, sir.
Bye.
Hello, can you hear me? Morning. Honorable Clopa,
Good day, Chairperson. I'm audible.
can you hear me?
Yes, we
I can hear you, Honorable.
Okay. Good morning, members. Good morning, all. You're welcome to the meeting. Well, today we are something is wrong with my sound. Members, can you hear me?
Morning,
Good
Chair.
morning, Chair. Yes, we can hear you loud and clear.
There's an echo.
Yes,
on-
echo,
on-
yes.
Oh,
Yes, I am hearing echo.
Yeah,
there
there is a disturbing echo, Chair.
Okay, members. It looks like the echo has vanished now. I'll request that my
Recording in progress.
request that my video be switched off. I think there is a general problem of signal in the parliamentary villages lately. Members, you are welcome to this meeting today of the committee receiving a briefing from the Department of Justice and Constitutional Development on interventions in the Master's Office. We'll then later get a briefing from Ms. Silkstone on statutory appointments. You'll remember that we deferred that item to today's meeting in the meeting we held yesterday due to time constraints. Then we'll deal with reports, committee reports on the draft notice determining the salaries of judges, magistrates, Public Protector South Africa, and the South African Human Rights Commission. I think I must make mention that the Committee Secretary, DG, I don't think it is appropriate for members to receive a presentation before the actual start of the meeting. I think let us strive to improve that situation. Members must get a presentation in time so that they're able to scrutinize it and best partake in the committee meetings. So I think we need to improve that aspect of sending reports. Committee Secretary, do we have apologies from members?
Good morning, Chair. No apologies.
Chair, Steve Swart here.
Yes, Honorable Swart.
I will need to leave the meeting early. I give my apologies in advance. Thank you so much.
Yes, you have a standing apology on Wednesday. Honorable Sotetsi.
It's not necessarily an apology on my part. I've just noticed, Chair, that there are people admitted to this meeting whose gadget are not named. You have Samsung, many Samsungs there, and so we do not know who those people are. Can it be corrected, Chair?
Yes, thank you very much, Honorable Sotetsi. Can we request everyone who has joined the meeting to accordingly name their gadgets so that we know who is in attendance. Committee Secretary who's here on behalf of the Department of Justice.
Chairperson, the DG is here.
The DG is here. Okay, then can you also attend to this thing of naming of the gadgets?
Chair, the relevant persons should rename their gadgets because I also don't know who they are.
Okay. All right, we'll monitor that. DG, can we get the briefing now on the interventions in the Master's Office from the department?
Good morning, Chair, and good morning to honorable members. First, I'd like to apologize. This is I want to start the new term with the portfolio committee, but we commit ourselves that it shall never be repeated, that documents are not submitted on time. We would like to apologize for that. Chair, I'm accompanied by colleagues, but most notably the acting Chief Master Advocate Kanyane Matibe, who will assist with the presentation. But few things that I would just like to highlight before we go to the presentations. Just to highlight that we have just had challenges. As you will know, the former Chief Master left last year in February. And since then, we have been on a recruitment drive trying to find a suitable successor. We were not successful, and we went back to advertise. And unfortunately, then there was a change of administration. In terms of practice, whenever an administration changes, there's not a moratorium as such, but we are discouraged to fill senior posts 6 months prior to the elections, which make a lot of sense. So as a result, we had to slow down. But secondly, the budget cuts means that in terms of the austerity measures, the National Treasury and the Department of Public Service and Administration manage the pay-sales of departments. So in other words, even when you are convinced you have a budget or you have budgeted for a post, you are not able to proceed and fill a post without a written and express authorization from the Minister of DPSA and the Treasurer. We have just been given such authorization, and over this weekend, we are going to advertise the post of the Chief Master. And our desire will be to, because it's a cabinet process, it must be finally endorsed by cabinet, that before the end of the calendar year, at least we must have concluded the process, all things being equal. And equally, we got funded for a post of a deputy Chief Master, will be responsible for operations. So we'll be advertising such posts, but equally as well, we managed to source funding for additional capacity across all the different master's offices in the country at different levels: assistant master, deputy master, and maybe some estate controllers. Because over the past 5 years, with the budget reductions, we're not able to fill posts that were becoming vacant in the different offices. So that's one area we'll be attending to. We received, as you know, the SIU report on the investigations into the affairs of the masters, which was done in 2020. It took a little bit of time, and they made recommendations on certain remedial actions, including disciplinary actions, that we needed to take. The processes are unfolding, and we're still within the confines of the law in terms of timeframes, and we just hope that we should be able to conclude the processes as well, so that those who have to come back to work are back to work, and those that may have to face other consequences face such consequences. Just to mention that the former acting Chief Master, who is the Master for Pretoria, we got a notice after she was put on precautionary suspension and having to face disciplinary, hearing, decided to tender a resignation, which we citing poor health and so on and so forth. And we have accepted that, and we'll start with the process to make sure that we look for a master of the High Court for Pretoria. So I thought I needed to just highlight those few issues. But the other notable improvement is that with the improvement in relation to load shedding over the past 3 to 4 months, part of what was a big challenge for us in that space of masters has also been alleviated. So because we were heavily affected, we were looking at measures as well, and we'll continue with those to make sure that every master's office has a backup generator. But I must say that our situation is better with the improvements over the past 3 to 4 months, where there's not been load shedding. And part of what we are looking at is a program that will be implementing very soon. Will be on training and capacity building for the master's offices, particularly the heads of the master's offices. So we're looking at the collaboration with an institution and the Justice College that will focus on really strategic management, including all matters of law management and dealing with stakeholders and complaints. But the chief master, acting chief master, and the team have started on a program of interacting with the stakeholders, be they insolvency practitioners and attorneys across the country. And we've made it a responsibility of every head of a master's office, every master across the country, to take the responsibility to manage the stakeholders. Because part of what we've observed is that a number of issues come down to poor interface and poor communications with the stakeholders. So we almost want to institutionalize it that on quarterly basis, the practitioners who do work in the master space must have the opportunity to meet with the master and interact with the master and deal with specific challenges. Previously, Honorable Breitenbach yesterday drew minister's attention to a notice in the master's office in Cape Town, which said the office was closed, but it was not meaning the whole office. They said the trust part of the office was not operational. And some of those challenges come along with part of what we're trying to do, the digitization of records, which hitherto have been manual, and we're trying to get them into a digital system. So in that whole process, getting files to be taken to storage, to be digitized, it becomes difficult when trust files are being sought. But the other services, deceased estates and the rest, have been open. But I have impressed on the chief master that I think that's not the way we should communicate. People who deal with trust matters are mainly people of means. It's not just an ordinary South African who will have a trust. So a communication in a different form, but stakeholder engagement, so that they can understand. What I found is that with the stakeholders in the masters area, they are very understanding and they are very sympathetic. That's why part of what we're doing now, we're reaching out to the banks. There's an initiative that the chief master is leading to engage with one of the biggest leading banks in the country, because they have said to us, we want to work with you, want to assist, whether it's capabilities in relation to digital related stuff. So we're going through due diligence to make sure that, even in our collaboration with them, we don't compromise anything on the part of the state. But we have realized that government cannot continue to work alone. Private sector has to come in and assist us. So I thought briefly, these are the issues that I should highlight. Part of a major highlight of the past 6 months, which the acting chief master will speak to, is the launch of deceased estates online. And that's meant in the main really to deal with this challenge of queues that you'll see snaking in the different major cities where we offer master services, to make sure that those who can transact at the comfort of their homes, like we currently are doing, they can do so without necessarily a need to go to the office. But as we do that, there are a lot of things. I mean, the technology, modern state of the art technology require that as well. Our capabilities here, I talk about laptops and computers are very old. We still have a lot of legacy, capabilities that we're trying to resolve. So, for example, even in Cape Town and Johannesburg, you find that we have deployed that, the online services, but some of the officials' computers are still old. And with the limited budget we have, we are on a program to make sure that the entire system is compatible in terms of new, desktops and laptops. With that introduction, I will ask the advocate Kanyane Matibe, the acting chief master, to make the presentations on the interventions that we have identified and what we are looking at in the next coming months. Thank you very much.
Thank you, DG. Acting Chief Master.
Good morning, Chair, and good morning to the honorable members of the Portfolio Committee. I just wanted to share with you the progress that we've made to date with the interventions that we had committed to last November when we came to the Portfolio Committee. And as an introduction, these are issues or challenges that are known and have been addressed to you either by the Law Society of South Africa or by clients across the country. We've had a few challenges with long queues, unreliable and slow systems, as the DG has now put it. We've had issues where, because of our manual systems, we would lose client documents. Also, some poor infrastructure, as reported in the Portfolio Committee's report upon their visits to various masters' offices, particularly poor infrastructure in Thohoyandou, in the Mthatha office. Also in the report was the Mafikeng office as well. There's also been perception of corruption raised by stakeholders as well as members of the Portfolio Committee and clients alike. And load shedding, as the DG has mentioned, has been a big issue for us. And all of that led to a huge number of backlogs in our processes. And again, the LSSA presented to you, and when they presented, these are some of the issues that they raised. And in November, we came back to the Portfolio Committee and we made commitments. And when we made commitments, there were 7 interventions or short-term interventions that we committed to implementing in order to address some of these challenges. And I would just like to take the Portfolio Committee through some of these interventions. The first intervention that we committed to was to rolling out the deceased estates online nationally. And we had committed to the Portfolio Committee that we would roll it out by the end of January 2024. And we are pleased to then inform the Portfolio Committee that we rolled out successfully on the 14th of December in 2023, a month earlier than anticipated. And this has also been rolled out to all 207 service points in the form of magistrates' courts. This obviously, as DG has already mentioned, it was in an effort to enhance accessibility and efficiency to the public, but also to reduce the long queues that we've been experiencing and the need for people to visit our offices in person, and minimizing also the delays in us completing appointments, examination of accounts, as well as finalization of deceased estates that had been registered with us. However, there are still issues. We have gone nationally, and I will share the stats, which I'm sure you have with you, but there are still issues that are still present, even though we've gone online. We interface with the DHA's National Population Register, and this is to verify people as captured by Home Affairs, whether they are indeed deceased or alive, and also to verify the relationships between the applicants as well as the deceased, and to get that association, the next of kin association with Home Affairs. When this is not working, which has been quite regular, stakeholders have submitted complaints in the past 3 weeks up until Saturday, where they indicated that this link is down most of the time. This is one of the challenges that still lead to backlogs with our appointment in deceased estates. And further to that, our ICT infrastructure that is still a bit outdated, and that leads to some interruption in the services in servicing our clients. And when the system is down, or there is the National Population Register through the DHA interface is down, that leads to repeat visits to the Master's Office. And just to give the Portfolio Committee a view, Chair, of all the cases that we've dealt with since January or December 14, 2023, To date, we've issued total number of cases that have been registered on the system, 9,250. And we've issued, of those 9,250, we've issued appointment letters in 7,611 cases. At the moment, the report is at the 6th of September 2024. There were 4 awaiting DHA validation. This is where the deceased names could not be validated, or the status of the deceased or the person whose estate is being registered cannot be validated as to whether they are still alive or whether they are deceased, or there are issues in terms of marital status of the deceased where it does not match with the information that has been presented to us. The 517 incomplete cases, these are cases where clients have started the process of registering an estate, but have not completed it. So it is not ripe for the master to make any decision on any of these cases, as they require completion from clients who have registered them. The rework cases, these are cases where we speak or communicate directly with attorneys, with applicants, real time, where there are requirements that have not been met. This was one of the complaints raised by the LSSA, that we do not communicate directly, we use posts. So this is a method that has now been used to close that gap. We are able to communicate with practitioners where requirements are not complete, or where there are still matters that require attention from the applicants. So there are 685 of them. The screen application, this is a representation of the cases or the matters where the masters must still take action and must still approve in order to enable a letter of appointment in either executorship or authority. So one would actually look at it as a representation of a backlog, though I would not qualify it as a backlog because it might still be within the 15 days turnaround time that we had committed to. This is just a view of the total applications per master's office. As you can see, Johannesburg and Cape Town, the uptake has been quite high. With the lowest cases being in Nelspruit, and these have been increasing. You see your small offices such as Bisho also registering a lot of cases than originally would have been thought. So this is just a representation. There is still a lot that would need to be done in order to increase the numbers, but this is an issue of accessibility as well as informing clients about the availability of the service. The letters that have been generated per office, again, Johannesburg and Cape Town in the forefront, and again, right at the bottom, obviously a representation in terms of the number of cases that are registered in that office would be Nelspruit. But we have seen quite an increase in the number of small offices, as I've mentioned. The second intervention that we committed to was on increasing education interventions on the master services, partly because the LSSA had submitted that we had not trained them on the online functionalities, and that they would like to be trained, and that is exactly what we committed to doing, and we executed that task. We developed training videos that will guide a user in terms of the use of the system. We publish them as YouTube links, as Facebook on our Facebook platform, and they may be accessed at any time by practitioners, members of the public, and these will assist them in lodging deceased estates application. They would also get a guidance in terms of how to book an appointment into the master's office for a specific time, for a specific date, and how to track the status of the application once submitted. And these are the links where the training guidelines and videos are available. And we've already to date conducted over 60 private training sessions at the request of clients, private law firms, members of the public, as well as international applicants who would like to register deceased estates for their family members who were not in the country at the time or who were living abroad at the time of the death. And these are some of the interventions that we've put in place. However, we are still planning, and we've already started with some of the community outreach programs where the intention is not just to educate practitioners, and this is to conduct outreach programs to members of the public that may not have access to technology to go and view YouTube videos or to go to any of our online platforms. And we would then be conducting some outreach programs starting next week with Wolves Week, though it is Wolves Week in collaboration with the Law Society of South Africa. We would then be educating members of the public on master services, specifically also assisting clients in registering estates online. We had also committed to increasing our engagements or improving our engagements and communication with stakeholders. The DG's already spoken to that. And I must say, we've had meaningful meetings with stakeholders since November 2023, either with FISA, which is the Fiduciary Institute of South Africa, with the Banking Association, and with the legal profession represented by different legal bodies. And we've also hosted a seminar where we trained stakeholders, and in that seminar we trained those that were in attendance, 2,300 legal practitioners as well as fiduciary professionals. We've also published these training guides for any of the practitioners or members of the public that might not have been present, specifically for any questions that they might have that had been answered in that webinar that we hosted. The masters that are present in the meeting today are holding provincial stakeholder meetings on a monthly basis in their provinces. And maybe also at this stage, it might be prudent to speak to the notice that was at the door of Cape Town. This was discussed and engaged with stakeholders on the 22nd of August, where no objection was raised by stakeholders as to the follow-ups of trust, but we accept that there are people that were unhappy with the notice despite that having been discussed in a stakeholder meeting. And we have removed the notice of the Cape Town Master's Office. We've also reconvened the Central Stakeholder Engagement Forum, and in these forums, we've taken several resolutions, and one of them I'm going to speak about now in terms of curbing corruption and the bribery allegations that have been purported by members of the fraternity. The load shedding issue, I am not going to address that much, but to say that these are the offices that we have that still do not have backup power, but I am made to understand that corporate services is engaging DPW, and it is at an advanced stage. Johannesburg does not have a backup power. Durban has, however, it is not efficient as the generator is not effective. Toyando, Mthatha, Mafikeng, and Gqeberha. But I just wanted to then mention what the DG said is there has been minimal impact because of the easing of load shedding, and we've had minimal disruptions in our daily operations, but we do recognize the need that there is still a need for a long-term solution should the load shedding issue ever recur. In terms of intervention 5, the DG has already spoken to it in terms of capacitation of the master's offices. The commitment was there would be a filling of critical vacant positions, including at the leadership position. And the vacancies there were 2 vacancies at national level that were deemed critical, being that of the Chief Master and the Chief Director Master's Operations. They have been advertised in the DPSA circular of the 6th of September. And this is obviously to ensure effective leadership and strategic management in the master's offices. but there is an additional 7 positions that would include 7 assistant masters across the various masters' offices, as well as 2 heads of offices in the form of deputy masters for the offices of Bishop and Middleburg. And we are looking now into phase 2, which once or if approved by DPSA, we would then be looking at an additional 21 critical vacancies that would help in addressing the capacity need or the inadequately staffed master's offices. Dealing with corruption was intervention 6. This was also submitted by the LSSA as there is a perception of corruption in the master's office. The DG has already spoken to the SIU reports, as well as our internal forensic reports. And just as an update, there were 14 master's officials that were charged with contraventions ranging from intimidation, maladministration, misconduct, and various other contraventions. We have had 1 official that has already been found guilty and dismissed, and we have 1 that was found guilty, received a sanction of a 3-month suspension without pay. However, we have filed additional charges against the same individual based on the SIU report. Just to mention, this official's disciplinary hearing was not based solely on the SIU report. It had been running before the SIU report was received by the department. That is why we filed additional charges based on the SIU report. We are also looking at completing some of these, or there is 1 SMS official, which the DG has spoken to, who resigned with immediate effect 2 days before their scheduled disciplinary hearing. What we've also done is during the stakeholder meetings that I have spoken about, the central stakeholder meeting, we've agreed with stakeholders, or the submission from ourselves was stakeholders needed to report corruption and any issues of bribery that they encounter in the master's offices. However, they then mentioned that they would not happily report any corruption or bribery, as they fear that their businesses, their firms, and their work may suffer, that the masters might not want to expedite their matters because they would have reported these issues. However, they would be more comfortable with an anonymous tip-off line that they can report issues at ease. We have developed this anonymous tip-off line in the form of a system, a mini web application that would be available to both internal staff as well as to external clients or anybody in the country that might have or that might want to report issues of corruption that they became aware of related to the master services. We plan to launch this in the last week of September. We are planning to have another stakeholder meeting where the functionality will be tested, and we would then be given the go-ahead to implement it. The question that remained was who gets access to the information that is reported on the anonymous tip-off line. And obviously our forensic, internal forensic audit unit would get access to that, and we want to limit the access to that platform as much as possible in terms of the back-end data to access the information, so that people are not compromised and that we maintain anonymity of the people that reported the incidents. However, anybody that wishes to be known or wishes to be consulted may choose to reveal their name, but if not, then they would remain anonymous and investigations would ensue. The issues that still remain is the disciplinary hearings of the other colleagues who had either not been dismissed or who had not resigned, and those are anticipated to be completed by the end of November 2024, as reported by our ER unit. The last intervention that we then spoke of was as regards to the FATF's mutual evaluation report that found our controls lacking in terms of beneficial ownership or in trusts. We are mandated by the Trust Property Control Act as the masters to create a beneficial ownership. These are as also part of immediate outcome 5. Create a beneficial ownership register, but also make that register available to law enforcement agencies. The last thing which the Act now mandates the master to do is to create a disqualified trustee register and inform trusts or any company where a trustee has been disqualified that this person is no longer fit and proper to be a trustee. We made a commitment that this was to the country that 1 April it will be available. However, when we were in the portfolio committee, there had been issues with the system. It had been implemented. Now we are at a position where it is fully developed, it is functional and implemented. We've given access to that register to several law enforcement agencies, which include SARS, the FIC, it includes the AG, it includes the SAPS. They've all made applications which we have approved, and we have given them full access to the register. And as at the 23rd of August, there were 61,141 trusts that had complied with the requirement of the reporting of beneficial ownership information. And there were 69 officials from law enforcement agencies to whom access has been granted, or direct access to the register has been granted. It's been used quite regularly by the NPA as well, in terms of the investigations into various individuals or companies. We do have an issue in terms of the current compliance level. 61,000 is still quite low, represents about a 14.75%. And we will be launching a multimedia prompt campaign in the coming weeks, where we would be urging trustees to voluntarily comply to the requirements, but also to remind them of the penalties of 10 million rand that may be imposed on any trust or trustee for non-compliance. We are still also in the process of developing a fully fledged trust online system, and it is envisaged that the system will commence from the 31st of March 2025. These are the long-term interventions that we had crafted and committed to when we came to the portfolio committee. However, we felt also that we should just also communicate some of the medium to long-term strategies that are in place, or that we've already started with, and that we can look forward to in the next coming years. One was the modernization and innovation of the master services. We've started with deceased estates. As you can hear, we are now going into trust online. The Guardians Fund, as well as insolvency system, will also be looked into for modernization in the coming financial year. We had looked into the creation of the Master's Contact Center, which the department is now taking over. We will play a role in that contact center, but this service will be specifically there's not just a query resolution as well as complaints, but to assist clients who do not have access to technology or may not have the means to travel to any of our master's offices in terms of lodging of estates, lodging of any matter that they may need to lodge with the master's office. We're also looking at an acquisition and integration of third-party data with intermediaries as well as other government agencies. We have already integrated with the DHA. We've integrated with SIPSIs. We are integrated as well as into the LPC to validate the standing of legal practitioners. You would remember we've had cases where bogus attorneys would present themselves to clients and would ultimately then dispossess them of property. The integration into the LPC role of legal practitioners has assisted us in reducing some of these incidents. We're also looking at focused interventions to specific target groups, and we're looking at improving the environmental conditions of all the master's offices. I would like to thank you, Chair. This is our last slide. Thank you.
Chair, that's the brief presentation. Maybe just one request that might be of interest, Advocate Matiba, if you can just speak on it, our outreach office. How much have we? I think we just left that out, but if you can speak of the CAF, the centers we have in the different courts where we provide some services.
Thank you, DG. Chair, we do provide the master's services. We have 16 master's offices. However, because this is not enough, we are assisted by 207 magistrates courts that also assist in master services. The magistrate courts, in terms of deceased estates, have a threshold of only of 125,000 and below, and they may then issue an appointment letter on those estates. This is to alleviate the backlog in the master's offices. Additionally, they do take in applications for the Guardians Fund. They are able to validate and verify beneficiaries with the Department of Home Affairs, after which then your profit centers, which are 6 master's offices across the country, would then deal with those applications. However, we've now, since the online system, we have a lot of the magistrate courts that have computers and working network and Wi-Fi that are able to assist us in online registrations of deceased estates. DG, is that what you wanted me to discuss through you, Chair?
Yeah, no, that suffices. In the next briefing, I think we'll be looking at a broader picture of the turnaround. I think we'll just speak more, even in terms of the challenges that maybe we experience in those areas. But Chair, this is the presentation. We're honored to make it to you and the committee. Thank you very much.
Thank you very much, DG. Thank you very much, Acting Chief Master. Members, that is the presentation on the interventions in the Master's Office delivered to the committee by the Department of Justice and Constitutional Development. Now I see Honorable Breitenberg. So Honorable Nomvalo. Honorable Matafa. Honorable Zotezi. Honorable Dana. In that order. Honorable Breitenberg.
Chair, can you recognize me? Apology, Chair. I'm still trying to find where I can raise my hand. Apology for that.
Oh, you have a conflict with your gadget. Okay.
Definitely, Chair. Yeah.
Okay, Honorable Mkhwebane, you'll come after Honorable Dana. Honorable Breitenberg.
Thank you, Chair. Good morning to everybody. Chair, my first questions are to the DG. I'd like to know a little bit more about the Pretoria Master. To which Master are we referring here? And you say that she's resigned or he has resigned, citing ill health. When was this particular Master suspended? And how long has the process been ongoing? I'd like to know a lot more detail about that. The appointment of the Chief Master, we haven't had a Chief Master for some time. I think you mentioned around 18 months. For me, it feels like much longer, but whatever. How is it that post hasn't been filled. Why hasn't it been filled? The explanation of funding and you know, not appointing for 6 months. I'm not sure how real that can be, given the importance of the position of the chief master and given the state of the master's offices around the country. Because a reasonably glowing picture has been painted here about master's offices and interventions and turnaround strategies. The facts on the ground are something completely different, and I think everyone will agree. I get literally hundreds of emails and WhatsApps a week from individual South Africans and practitioners, all of whom are too afraid to complain very loudly because then they say their matters will never be dealt with. So the picture painted here and the picture that South Africans are experiencing, two different things. So why was the position of the chief master not funded, or what was the problem with the funding, and why was no appointment made for such a length of time? So it's a key position, and it needs to be attended to. Then to the acting chief master. Just with regards to the Cape Town matter yesterday, madam, let me just find the photograph that was sent to me, which I sent to the minister and the deputy minister. It reads, it's stuck up on a window, or I presume a window where people come to be served. No trust follow-ups for the rest of September month. That's it. No trust follow-ups for the rest of September month. So, I mean, what is that exactly? I hear you saying that you had an interaction with stakeholders and they all said that's absolutely fine. Who were these stakeholders? How many of them were there? And how does that help the members of the public who schlep from 4 o'clock in the morning in Cape Town, spending their last little bit of money on a taxi to get there, to find that stuck up on the window? How does the stakeholder interaction help them? And why is it, this isn't the first time I've received such a notice, a photograph of such a notice. It's not the second time, it's not the third time, many times. I don't know about other master's offices. I only know about Cape Town because they're the ones that are sent to me. I presume it happens elsewhere. How is it acceptable when people, members of the public who need to access your services, come from many miles away under not great conditions? They don't hop into their car and drive here. And then they find that stuck up on the door. I've had photographs of pictures on the door of the master's office. The outside door, before you even enter. Systems down. Sorry, you can go home. How is that okay for somebody who's come from travel for hours? It's not okay. That is not service delivery, and you cannot treat South Africans in this fashion. So please explain to me how this happens. And when you say you engage with stakeholders about it, who do you engage and how? Because it's not reaching the people who slept there from 4 o'clock in the morning, I can assure you. The general problem with corruption in the master's office, I think you and I can both acknowledge that it's a massive problem. And practitioners, as you said, are too afraid to lay charges, because then they say their matters will not be dealt with, not be expedited, not be dealt with. The documents will just disappear. So how do you propose to deal with that issue effectively? Some of your interventions sound really helpful, and I'm pleased to hear about them, and I sincerely hope that they work. If they bring about a turnaround, how wonderful. If this committee can assist you in turning it around, please let us know. Don't wait 4 years. Just let us know. We're all wanting to help you make this better. Believe me. Because I'm sure I'm not the only MP who gets complaints on a daily basis about the master's office and the chaos that reigns there. You also mentioned, acting chief master, that some officers use a manual system and therefore documents get lost. Why? Why would that be? Do you not have a filing system? Why do documents get lost? If they properly, the master's office deals with important documents. There should be a proper protocol in place to deal with documents. They shouldn't get lost. It's not acceptable. Can't blame a manual system. Before the advent of the computer, manual systems worked very well for many years. So they do work. And then I'm a little concerned about the investigations and charging of corruption and getting a sentence for corruption in the master's office, where you occupy a position of trust. getting a 3 months without pay suspension, and then you come back to work to do what? Carry on being corrupt. I don't understand that at all. How does that work? Those are my questions. Thank you, Chair.
Thank you, Honorable Bredenbach. Honorable Nomvalo. When you have time, you must rename your gadget properly. You have missed L in your surname.
Oh, no, I get that, Honorable Chair. Greetings, Chair, and greetings to members of the committee, the DG, and the acting Chief Master. Chair, I think the first point that I would like to make is that the majority of clients who are serviced by the Master's Office are poor people, and the majority of whom come from the rural areas. So it's a vulnerable group that needs to be protected, at all costs. There's one thing that, notwithstanding the challenges faced by the Road Accident Fund, but there's one thing that the modality that they adopted, which I applaud, and which I think if it can be adopted by the Master's Office, it can help the situation. Many people, when they die in hospitals. So what the Road Accident Fund did is that it decentralized its personnel. There are people who are on the field. Upon the death, they immediately intervene right in the hospitals. And when people get injured, they just issue them with forms and so on. So I think, Chair, because I'm saying this because there are many estates which are not reported because of ignorance. People don't know what processes they must follow, and some don't even know that when a person dies, their estates must be reported to the Master's Office. I'm talking about the deep rural areas. So I think we must also, or the Master must also consider that modality of saying workers must not all be office-based. There must be some. I appreciate the effort of having centers in the magistrate courts. But the last time I checked, the work that was done by those centers was minimal because they were only issuing letters of authority. They were not issuing letters of executorship. A person, when he applies for a letter of executorship, he will be told to travel many kilometers, from their residential areas to the Master's Office. For instance, where I come from in Mzimkulu, there's no Master Office. People rely on the centers, on the Magistrate Center. So for a person to have access in the Master's Office, they'll have to travel to Pietermaritzburg. And remember, some of the estates are complicated. They require the attention of the actual Master's Office. For instance, an estate of a deceased who was married in a customary marriage, when there is no marriage certificate, the Master must go through an inquiry to ensure if that marriage was in existence, before that. So you've got those challenges. I think we must think, beyond the centers that we have in the magistrate courts and decentralize them to hospitals. And that can help in minimizing the queues, the long queues now in the Master's, offices. And then what I think is also contributing to this thing of long queues is the turnaround time, which is not consistent and which is not accurate. Some people, even when they've submitted all these required forms, they wait for their letters to be issued for more than 2 months, whereas some get their letters within a day. And that opens a room, for suspicions. for corruption, and bribery, because you don't understand why this inconsistency is taking place. So if there can be a turnaround time and if there can be an online reporting system by the masters on a weekly basis to report to the chief master that in this master's office, this is what we have done. These are the cases that have been lodged. I mean, these are the estates that have been lodged, and these are the estates which have forms which are not complete. And this is how we've advised the client to complete the forms or the application, so that you people can account for everything that is happening in office, including the late issuing of the letters. So I think we need to intensify the reporting systems in the master's office, and it must be done on a weekly basis. So the master's office must develop an online reporting system. And I think for that, to happen, they would need maybe to liberate the master's offices with gadgets, so that they will be able to report online and so on and so forth. And then I think there needs to be a proper, another issue which I don't understand. The banks, before they open the estate late account, they need confirmation from the master's office. Okay, that I understand, because people were falsifying the letters of executorship, and they presented falsified letters in the banks, and the banks would based on that open an estate late account. So now they need confirmation. Now what I don't understand is that, and I'm talking about practical cases here which have experienced and which have come across. Some of the banks, some of the estate controllers take time to confirm, just to confirm that, no, we know that letter of executorship, it has been issued by us. Some take even a month to confirm. A client, moves from pillar to post trying to get confirmation, and that delays the process, because the bank, understandably so, cannot open the estate late account before getting confirmation from the master's office. So, Chair, the interventions must not only be theoretical, but they must have a practical influence, in dealing with all these deplorable circumstances under which our people exist. The issue of queues is still there. I'm not really convinced that what has been presented by the acting, chief master here has actually dealt precisely with the issue of queues. The issue of queues is still there, Chair. People are still queuing up, and some go to the master's office and go back to their homes without having received any kind of assistance, because they will be told that, we're closing our offices now. The government only pays us for 8 hours, in a day. So we cannot work overtime. But I think what we must emphasize to the DG and to the acting, chief master, is that they must make it clear to their centers that we will do oversight. We will do announced and unannounced oversight. And sometimes we won't go there as a team, even as individuals. So in that regard, we will really need their assistance and their cooperation. In this sense, when you go do oversight in these areas, sometimes there's resistance. Sometimes they don't cooperate because they start to question your credentials, in a slightest provocation. So we will definitely need your cooperation so that when we face such resistance at DG, we just call you directly to say, I'm here in Durban or I'm here in Pietermaritzburg. They don't want me to access, the precinct. So kindly assist in that regard. I think I once confronted that, but not in the master's office or not in the context of this portfolio committee in correctional service. And the commissioner was so helpful, because I just called the commissioner immediately and he intervened. So I'm saying that would also assist to ensure that there's efficiency and to ensure that people are properly serviced. Because when we do more unannounced oversights, people will always be at work, on time because they don't know when we'll arrive. Yeah, for now, Chair, those are my submissions. Thank you very much.
Thank you very much, Honorable Nomvalo. Honorable Matafa.
Thank you very much, Chair. Good morning to you, Chair, DG, Acting Chief Master, members and guests. Chair, let me start by thanking the presentation and confirming that now it is helpful and will assist going forward. Chair, maybe my starting point would be to reflect on expected progress report timeframes, especially also for the benefit of the committee as well. I would implore the committee to look at scheduling follow-up sessions so that we see that the interventions as presented are in line with the commitments that are made. Chair, the second one is just to welcome the inputs as far as the filling of critical vacancies are concerned, and also welcome the digital rollout and to say that we note that it's in line with the commitment that was made. On the same congratulatory point on the digital rollout, can we be taken into the confidence of the office if whether the system is interactive to a point that it can also allow electronic communication like the email platform? We know that most delays are also as a result of communication that is either cumbersome or maybe it's not conducive to the user. And this, Chair, I'm focusing on the deceased estate management. So if we can just check on that one, if whether can it be interactive to the point of electronic communication. Another one, Chair, is just to find out how is the turnaround plan responsive to the legislative changes? I'm thinking what comes to mind is the Trust Property Control Act amendment. I know they'll be adding additional responsibilities on the side of the Master's Office. Is the turnaround plan responsive to that? Will it give enough capacity and systems to be able to respond to additional requirements that are required of that particular act? Chair, the fourth one is on the education, the slide on education on master services. And I'm linking this to slide 15 as well, where it speaks to medium and long-term interventions. It speaks about education programs that will be provided. My view tells me that the programs are outward looking. My question is, do we have any programs that are inward looking in order to capacitate the the internal staff to enhance efficiency and competency, which I think will also result in a better customer service and enhance staff morale. And maybe to a somewhat extent might address what Honorable Nomvalo is raising, inconsistency in the supply and delivery of service to stakeholders. Chair, my last one is on the combating of corruption. I welcome the interventions, particularly the tip-off line. It's a good initiative, but my question is, are there any deterrent or preventative measures that the department is considering to put in place? And I'm thinking an example could be re-engineering of the systems, processes and procedures internally, so that if there are safety features that can be installed in systems, have they been considered? And I think one other example that we can use, I'll borrow again from Honorable Nomvalo. He's speaking about a reporting system that should be online. It can be a deterrent and a preventative measure as well, when the reporting is available and explicit to any interested party. So fiddling and playing around with information might be prevented with such an intervention. So the question is, besides the tip-off helpline, are there any other internal measures that the department is considering? Chair, those are my questions. We appreciate the hard work and the good initiatives that are presented in the turnaround, and we have faith that it will succeed, and the committee will give full support to where we can. Thank you so much, Chair.
Thank you, Honorable Matafa. Honorable Zotetsi.
Thank you very much, and good morning to all those that are in the platform. Now, as a first thing, Chair, look, I would propose that the committee looks at interacting with the Master's Office on a quarterly basis. And this should be done so that we're able to monitor the progress on these improvements and compare it with the actual observations that we'll be making as we do oversight. I think there is normally not in relation to what we're dealing with, or I don't know if it would all be, but what is the ground. So I think that the court that would be made in as far as improving the work and the efficiency of the Master's Office. I'm not sure what happened. Was I still in the platform?
No, you got cut. You don't cut. You got cut. So, but we heard you when you said interventions in the Master's Office. So I think if you can start there.
Yes, so the point that I was making is that if we couldn't have quarterly interactions with the Master's Office, it will assist us really to babysit the progress that they will be making in as far as improving the outlook or even affecting their turnaround strategy is concerned. So that's the proposal that I have to the committee. The second thing is that the issue of corruption, we are not sure, or we have not been briefed on what exactly are the details of this corruption and how has it played itself out. Now, one just gets to wonder whether this corruption has not, how much has this corruption affected the resolution of matters of estates? Has it actually trickled down to affect ordinary people, where you will find that people's estates are actually allocated to incorrect people as a result of the corruption. We are not sure about, we've not been brought to light as to the extent of this corruption. And if that is the case, is there anything that the Master's Office is doing to correct the situation? The reason I'm asking this, Chair, is because the area where I'm coming from in Rustenburg it has a number of these cases that are prevalent, whereby you find that the assets of a deceased individual would all of a sudden be inherited by people who were very much strange to that person. And then all these things, you will find that they are coordinated from the Master's Office through the collusion with some law firms and so forth. So this would speak to the corruption that is there. And then if the instance of that nature happens, how much is incorporated into the turnaround strategy as it relates to those people recouping their assets? And I think that in the next session with the master, will be able to bring individual cases in detail. But are they aware of such? And then is there anything that would be done to resolve that problem? Now there are 14 officials that are charged. I would have missed the specifications around these figures. Can I just be brought into light? Is this accumulative?
It has nothing to do with you.
Mr. Malisela. Mr. Malisela. DJ, there's some person here who's Mr. Malisela, who's from the department, according to how they name their gadget.
I will attend to him, Chair.
Sure. Please proceed, Honorable Sodetse.
Yes, as I learned, Chair, so I was going to ask if these officials, is this figure of officials that are charged, is it accumulatively of all the offices, the master's offices, or is officials charged from one particular office and so forth? So let me pause there, Chairperson. Thank you very much.
Thank you very much, Honorable Sodetse. Honorable Dana.
Thank you, Chair. Good morning to everyone. And thank you for the presentation. I think we welcome the interventions as well, and I really truly hope that they work. However, Chair, I don't think that the progress that was presented here to us today completely corresponds with the experience of people on the ground measured against the number of complaints that we receive on a daily basis with regards to the master's offices. So, and many of my questions have been covered by some of the colleagues. I'd just like to know, I have 4 additional questions or things that I'd just like to emphasize. I'd like to know if the progress being made and the turnaround plan is also communicated to stakeholders like practitioners and the public at large, so they at least know that there is a plan being made, that there is an attempt being made to turn around the situations in the master's offices across the country. That's my first question, Chair. And then secondly, I didn't see anything about the infrastructure of the master's offices, the physical office buildings. Is there any plan or correspondence with public works or building owners where the master's offices are? Because as we know, some of these offices and office spaces are also in a deplorable condition, which has a direct influence on the people who work there and an influence on the work that they do. I can name an example. For instance, there was a sewage problem at the Free State Master's office not too long ago, and it was so bad that some people just could not work. So that has a direct influence on the output of these offices. So I'd just like to get some feedback on the office facilities where the staff of the master's offices work. Then, Chair, thirdly, I'd also like to emphasize the appointment of the chief master. This has been coming a long way, and it's something that needs urgent attention. And I think we should also request urgent feedback on this matter. When will a new chief master be appointed, and what is the reason for the delay? And then lastly, Chair, South Africans are used to coming to state departments and hearing the system is off. But I've never heard so many complaints of the system is off or offline from master's offices. Now, I'd just like to know, is there a skills gap or something? Is there an internet gap or what is going on with the master's offices systems that it's always off? Not, well, I'm exaggerating if I say always, but it happens so much. We get so many complaints of people saying, I went to the master's office, I sat in a queue for hours. When I got to the front, they told me the system is off. How is it possible that the system can be off so much? Is it a CETA problem? Then we'll have to look at maybe not working with CETA anymore. And I know that the department has already complained about CETA in the past. Is it a skills problem? Is it an ICT problem? Is it an internet problem? What is the reason for the system always being off? We need answers on that. These are the practical things that have to be addressed before the backlog can be addressed and before people can be served. And then I'd like to know the reason behind, I didn't hear it and I apologize if I missed it, but I'd like to know the reason behind the notice at the master's office in Cape Town. You can't just put up a notice and say nothing for the rest of September. What is the reason for that? And are there any consequences for the person who decided just to waste everyone's time and just put up a notice and say nothing for the rest of September? So, Chair, those are my questions and I'll await the answers. Thank you very much.
Thank you, Honorable Dana. Honorable Mkhwebane.
Good morning, Chairperson. Thank you so much for the presentation, Chairperson. I asked earlier about the identity of our acting chief master, but we will see her when she responds. Chairperson, my questions and clarifications are as follows. Indeed, the presentation is promising compared to last year on the 6th administration when we received the presentation or the complaints from the master's office. I'm saying it's promising because they're showing us that they've put systems in place to address our concerns. But then can I get clarity on the statistics which they've presented? Incomplete applications, the 517. What is the master's office doing to follow up? Because those applications will stay on your system and they will reflect as backlog, or you find yourself having to account for them. How do you make sure that you have a triaging process in the sense that when a complaint is first lodged, every information and documentation is complete and before you process it? Like, I mean, you see a pension fund where the 60 days start kicking in when all the forms and the application is submitted and everything is complete. So that's where then you can say you are failing to do your responsibilities or to process a complaint on time. So on these ones which you have currently, are you following up with the applicants? Are you going back to them, submit the following document or do the following? Just clarify. But I think going forward, you should make sure that when you log in that complaint in your system, already every document is submitted and every information is there. And that will then help you to have AMA service standards. I think the last time I asked, do you have a service standard document like your standard operating procedure, but which will tell you or tell us as members of the public and which will be on your website? I heard you were talking about 15 days. Is that published everywhere in your website, in your offices, so that any person will know, and even in the magistrate's offices, that my application will take so much to process? And then I see Nelspruit office has very few applications, and I just wonder, because this issue of demarcation and having to have head office or the master's office in Nelspruit, and you find that people who are in Witbank, Middleburg, or even Wamhlanga and them, they have to travel more than 300 kilometers to go to Nelspruit. And indeed, I agree with the honorable member Nomvalo to say a lot of the victims or the people who are your clients are the poor of the poorest and the vulnerable. And I see the good work you are doing in the various magistrate courts. But then the question is, what if the impacted or the affected clients are the ones whose application is above 125,000 and whose applications is complex and would need the letter of executorship? And again, linking it up, possibly for instance, people from Wamhlanga might travel to Pretoria, and you find that the Pretoria office has the highest number. And is that allowed, that a person is staying in Mpumalanga can then apply in the Pretoria office? But again, as far as that is concerned, how do you make sure that the people have proper access, they are processed in the areas where they would be staying? The issue of customer complaints, do you have a responsible section or an individual where complaints can be lodged? I hear you speaking about the anonymous complaints, which is good, and that number and that process, by when we do activate that particular anonymous complaint. And then besides the anonymous complaint, the complaints by members of the public. I think the last time I also raised it, and those are still the complaints one is receiving. Where a person is not happy with the executor, they complain to the master's office to remove that executor. The master's office is not acting expediently. The master's office is also not helping the very same poor person who's now finding themselves with this legal practitioner who's failing to act speedily in finalizing the liquidation and distribution account. What are you doing about that abuse? Because some of them will just say, go and complain to the LPC. Now this poor person is left with this person who has been using the account or this fraudulent transaction. What can you do as the master's office to properly link with the LPC so that we know that when a person is complaining, automatically you refer the matter. You don't leave this person to on themselves go to the LPC, which will also take its own process, whereas the matter is hanging and is not dealt with speedily. And the issue of the which is good that you in the magistrates' offices you have this outreach, and people can now go to the magistrates' offices, but as I said, it's still not enough. Issues of liquidators, the inadequacy of checks and balances when it comes to the appointment of the liquidators. And the question is, I know there is that issue of the insolvency policy, and that is a very contested case, especially the refusal to transform and the wanting to keep the status quo. And that process, how far are you in compiling the policy, and which will then also make sure that we have liquidators which will transform that space as a country? And then finally, the issue of the Guardians Fund. How far are you to recover the monies which were lost through the double payment, and the officials who were involved? How far are you? And are there any now internal controls in the system at the Guardians Funds to detect and prevent unauthorized transactions? I think Honorable Matafa mentioned about that in another context, but in this context, how can that process be put in place? Because the key issue, Chairperson and honorable members, the public would want to experience the master's office, and when they go there, don't stand in the queue, your matter is processed expediently. So I would appreciate clarifications as far as that is concerned. Thanks.
Thank you, Honorable Mkwebane. Advocate Sally. Advocate Sally. Advocate Sally.
I think he's written a message privately. He's going to try a different device.
Oh yeah, I've just seen that now. Thank you very much, members. We are going to take Advocate Sally in a different round of questions. TG, there's an issue with filling of vacancies in the master's office, which I think that in itself affects the negative performance as it relates to the master's office. It does look like we still have a number of vacancies. Maybe if you can brief the committee on how are you planning to fill those vacancies and what are the timeframes to that effect. All of them, not only the vacancies of the chief master, but all of them. Because if we continue having people on acting capacities, it's going to, if it's consistent and it does not stop and those vacancies are not filled, is the situation. Look, there is another thing that I think maybe you must brief us on how best as the committee should we assist the department. We recall that the president in his opening of parliament statement did issues relating to cutting of red tapes and ensure that we accelerate service delivery. And from where I'm seated, the program or the process of approving a post is quite long. If you're going to the minister, you're going to write to the Minister of Justice, the Minister of Justice must approve, then write to the Minister of Public Service, the Minister of Public Service approves, then it goes to the cabinet and stuff. I think from my point of view, that kind of process is quite strenuous and may in a number of circumstances be part of why we still have vacancies in our entities. And I think maybe if you can advise the best way that which the committee can help the department in that regard. It's quite too long. Of course, using a commitment by the president. The issue of digitization and estate online, we've been discussing that since the 6th Parliament, and I'm sure the 5th Parliament as well has been actually discussing that kind of a progressive program. Now, if you can brief us on how have you been able to allocate budget in your APP, strategic planning and budget? How have you been able to cater for that particular kind of program, the estate online and the digitization of records? Because you remember, Parliament has been complaining about the digitization. We've done a number of oversight visits in masters' offices across the country. And the central problem was that the manner in which files are kept is actually risky and very much problematic. And also the issue of the infrastructure. Have you been able to cater for that in your APP, in your strategic planning and budget? The last issue would be the issue relating to the SIU investigations. What had actually triggered the SIU to investigate the master's office? AJ, we'll start with you, then we'll give the acting chief master.
Okay, thank you very much, Chair and honorable members. Maybe let me start with the question that came earlier, the first question, which was from Honorable Breitenbach, the chief master vacancy. As I indicated in my opening remarks, the chief master left last year in February. And it was not like unexpected. For 6 months, we had been engaging him to stay on, but then he left. Now, the chief master is at the level of a deputy director general. So as the Director General, my role is limited to making sure that the post is job evaluated. Secondly, making sure that the post is advertised. And thirdly, making sure that the panel sits, which is supposed to be chaired by policy by a minister, supported by 2 deputy ministers plus the Director General. So the schedule of the panel members then can become an issue. However, the post was advertised and the panel set to do the shortlisting. Unfortunately, the responses were not considered to be responses, or the application were not considered to be responsive, in the sense that they were not meeting the post requirement. Now, the process was started again with whatever the necessary adjustments that might have created a problem for the market not to be responsive. And that happened again, ran back that same process, and panel said, the panel was supposed to now be constituted and sit. Unfortunately, as I mentioned then, elections, 6 months before the elections, the practice over the past 6 administration has been that posts at that level are not filled 6 months before the elections. The practice is to wait for elections and then you proceed. But just the point that, Chair, you have made at the end is a serious issue you have observed. This much I can say. From April, there was a communication by the former minister to ask the former minister of DPSA to give us authorization, because we had secured the budget from Treasury. We made a case to Treasury, and Treasury agreed that we needed to be given resources as the Department of Justice so that we can assist, make sure that the courts and the justice services continue to function. But in spite of that, the circular requires that minister must write to the Minister of DPSA, who then engages Treasury. Treasury then comes back confirming that we have a budget. When Treasury had confirmed, the former Minister of DPSA, who should have written a letter authorizing the Minister of Justice, was on her way out, and inauguration happened. After the formation of the 7th administration, they sent a circular and say, you must restart the process. The new ministers must be briefed about the post. You can't continue on the basis of your former minister's request. And obviously, it's the same financial year. The financial year started on the 1st of April. And here we are with a new administration in July. They issue a circular and say, restart the process. Now we had to start the process. The current minister had to sign to the new minister. A communication came back from DPSA with errors, not covering all the posts that were requested, that were indicated that these posts are funded. We only got just a week and a half ago a final correct authorization. And that's why I was then mentioning this point that then we'll do the advertisement. From our part, administratively, I want to assure you that the closing date will be the end of this month. And we will do all the necessary that relates to the panel sitting. And the DG will avail himself to be part of that panel. But we have no control over the principals are new, the minister and the deputy minister. We have no control on their schedule and their availability, but we'll impress on them that this is necessary, that it is urgent. And I agree with Honorable Breitenbach that you need to have a chief master in place, because you can have all these nice looking turnaround interventions. But if you don't have a main person who will drive this, then it becomes a challenge. Then, of course, that process then must go back to DPSA, who then takes the matter to cabinet. So the sitting of cabinets in our planning was that we are targeting that at least the cabinet of mid-November should be able to process that matter, the position of the chief master and other DDG posts that might be advertised as well. So then you take into account processes of a notice. You are looking ideally, if the chief master, wherever they will be, have to serve a notice, or the prospective chief master, you look at the possibility of them starting either in January or February. So that's the situation. But I must mention that the department last year, in the middle of a financial year, in August to be precise, lost $1 billion. Treasury came and said, no, from the budget we had given you, we're taking away 1 billion rands from the vote. And they did. And what that did was then to say all the vacancies that you had, whether you had advertised or what, they are all declared unfunded. And that was the consequences. And that even affected, so the masters was not immune itself. The offices across the country got affected. And we had to go back, start negotiating, and the plan was that over the MTEF period, that's 3 years going forward, the budget of the department was going to be reduced by close to 7 billion. We entered into a discussion, and part of the commitment that the criminal justice and security departments should not really be, their budget should not be reduced to that extent. And we then managed to reduce that budget reduction by 7 billion to maybe under, just maybe around 2-point-something billion. And now the consequence again is that we can't fill all the posts that were vacant. We have now to identify what is considered to be critical posts. And that's the process that now we are undertaking, that will be advertising. And of course, the situation doesn't get easy. As we run disciplinary hearings, people are being dismissed, others are leaving. You will have seen the past 2 weeks that we confirmed that disciplinary hearings across the country for different matters returned sanction of dismissal of close to more than 80 officials. And then 80 of those had to go through an appeal. And as of the update of last week, more than 60 of them, the dismissal was confirmed. So these dismissals now means posts are vacant. We must go and run that process. We are trying to engage the DPSA to say, for this current financial year, if a post becomes vacant, either through termination, resignation, or promotion elsewhere, we shouldn't be subjected to that process. We must be allowed to fill that post. So we'll see what the response is. Now, which master has just resigned? This is the master of Pretoria. So this is what happened. The Master of Pretoria, after the Chief Master had left, was appointed an acting Chief Master. So was an acting Chief Master from last year, March, until March this year, and was put on precautionary suspension. And this was on the basis of whistleblowing that was sent and an investigation that was done by the internal forensic of the department, looking at matters of an appointment, the unlawful and illegal appointment of a liquidator who did not qualify because was even the court had declared that was not fit and proper to be appointed, but was appointed. And we learned through the media last year that there was this appointment, and the matter was investigated, and we discovered that the acting Chief Master, as then she was the Master of Pretoria, was involved in that process, and hence then she was suspended. Report was finalized, charges were preferred, and the matter should have set sometimes in July, but there were some postponements. And August, the matter was supposed to proceed until last week. Then we got a resignation saying, I'm resigning, I won't, continue in the employment of the department. And we accepted. And I was just saying, the reason cited there is, due to poor health. Then I've decided to resign, and we accepted the resignation. The fighting corruption in the Master's office, is not a child's play. I must say this much I must say. It is a challenge and still a long, bumpy road ahead. I know we have questions about some of the things that I had said. I was quoted by the media a month ago having said that when the SIU was proclaimed in 2020, maybe to come back to the chair's question, as well, we had received the whistleblowers, the ministry had received a report from whistleblowers about all manner of maladministration, corruption, malfeasance, and all of that. And the view then was that SIU needed to come in and do the investigations, and then they presented a report, made recommendations for disciplinary, as well as referred some matters that they felt were criminal to the NPA. We're still waiting for an update from the NPA whether they will prosecute certain matters or they require further investigation on those matters. Now, just when we took an action and put those that were identified for disciplinary on precautionary suspension, we started being subjected to pressure from people from outside. And this is the problem, that the corruption in the Masters is not exclusively done by officials. It's a high level of involvement of people from outside, and particularly when it comes to issues of liquidation. So I'm very happy that, as Honorable Brettenbach says, that you want to help us, you work with us. We'll be very happy, because pushbacks we will get, and not just pushbacks, serious pushbacks. And I did at some point end up making a point that when the former Chief Master was leaving, we tried to understand, and I even asked the minister to intervene and say, but the Chief Master has just been here for 2 years, why is he leaving? And we couldn't get, until then we discovered in the process, when now ourselves are dealing with these matters, that the amount of pressure that can come from outside, and people were so daring in our case to even write with their identities known. And that's why I went to the police and told them that, but this is intimidation. You can't expect us to manage and administer the department, and people outside can just write and say, why are you suspending our comrade? What are you doing? And so on and so forth, when we have a report from the SIU. So that's a serious challenge that we will work on, and we'll be happy to have your support in dealing with it. So we'll not only advertise the Master or the Deputy Chief Master's position, we will advertise the other positions as well at operational level, at the Master's level. And now, of course, the Master Pretoria post, we have to try our best and advertise it. At least that one requires administrators like the DG to finalize it. We don't require the minister to run the interview. So we will try our best that before the end of the calendar year, at the least, when we come back, we must say that we have already appointed a master for Pretoria, and the same with the other posts that will be vacant. I know that the acting chief master may speak about this. In places like Mpumalanga, indeed, Honorable Mkhwebane, you'll have people concentrated in your Middleburg, Witbank areas. Then we were opening an office. I think it was just an issue of the capacity that we're challenging, but we're opening an office because of the realities of the province, the Lowveld and the Highveld. It's a long distance and unfair to expect people from the Highveld to go all the way to Nelspruit. But also, I know that there's a flexibility that people can still come to Pretoria for services, in spite of the fact that even Mpumalanga as a province. The insolvency policy. There was a policy that was done, and it went all the way to Concord. We have agreed that we are correcting what the Concord has raised as a challenge, and take it back up again for the minister's approval and whatever the role the stakeholders have to play. So we commit that in the next, in 2 months' time, we must have finalized that process. The issue of the system and CETA. I know that in the 6th administration we're meant to have CETA come and appear before the committee, because these issues you are raising now about the system is just a drop in the ocean of the problems we have with the system. When we come to brief you about general matters of the administration of the courts, you'll realize that we really have a serious challenge here in terms of the procedure. So the red tape that you talk about, having to go to CETA and so on and so forth. The former minister had written to 2 different ministers of communications, because there were changes there, asking for exemption and said, can you exempt the department from your processes? By the way, part of the reason why SARS is known to be, highly technologically advanced and digitized is because SARS is not subjected to CETA. And sometimes when you sit with the national commissioner and he briefs you about the systems that you work, you can feel like you are incompetent, when in fact you are not. It's the reality that by law, the CETA Act says that the following things must be done through CETA. CETA, okay, I shouldn't venture into the challenges that CETA has, but the point is that they know if we come here, we will say it in their presence. But we have challenges, things are just not moving. And part of it is because now they must then get involved in procurement and so on and so forth. So that's what I must say. It's not because we are incompetent, we don't know what we want. We do communicate, we write specifications and say, for masters, this is the type of a system we need. But there's a reality as well of budget cuts. The department has over 17,000 employees. There are some offices in the courts and even in the masters where people are using a gadget that is more than 10 years old. More than 10 years. So you may wish to have them have a new laptop or desktop tomorrow, but there's a reality that the budget is not sufficient. But we have started on that process, and we hope that we're given ourselves a time frame that at the least by mid-year next year, we must have everyone have an updated desktop or laptop that is not more than 3 years old. So that's the process that we are running on. The digitization of records of the department. The honorable members who have been going around doing oversight, you will have seen how the state of our documents, and in some cases you get worried that if there was to be fire, a lot of records are gonna be lost. But again, just that process comes at a big cost. So we had started to look at urgent, critical files that must be taken into the system, including in the masters and in Cape Town, Joburg, Pietermaritzburg, and Pretoria. There's just been some prioritization. So we keep trying to find resources. We have approached CARA fund, and we're given some resources to find a way of getting scanners and run a project with intents to make sure that we complement the current storage and digitization project to increase. But it's going to take time. It needs something like a 3-year project that whenever we have some savings, we invest in the digitization of our records and do away with records that are not necessary. Sometimes you come across records that are more than 30 years old. But in master's matters, you get told that age of the records is not what determines whether you still need those records. But in the courts as well, you have some of those. There's a cabinet decision of 1996 that had placed a moratorium on destruction of records. So part of what we want to do is to say when a record has been digitized and you destroy the hard copy, it's not the destruction of records. So we need to have cabinet at least share the same interpretation and because at the time, I think there was a particular reason why 1996 cabinet felt we can't continue with destruction of records. Infrastructure, indeed, Honorable Jenna, it says is a big problem across the country. Even here in Johannesburg, you go to Johannesburg, you can't believe you are in a government building that must offer services. But what's the problem? The problem is public works. All the time I go and scream about it, talk to my colleague DG, they tell you they are working on it. Our offices, provincial offices in Johannesburg, next to where the masters are, you look at the building, the landlord, in fact, the leases for both buildings, the provincial office as well as the master's office, have expired. And the landlord tells you, I'm not going to do anything because I don't know when you are leaving. So it's running on a month-to-month basis. And you ask public works, but when are we finalizing getting a proper building for us to provide services in a decent place? You never get an answer. You keep on hoping against hope. I know that in the 6th administration, we were called with public works, maybe a follow-up to that meeting as well, to say the decisions that were taken in that 6th term, how far have we gone in terms of implementing them? And maybe the new political principles that are there as well will look at things differently. But the reality of the matter is that infrastructure is a challenge. Not only the master's office, the different, you know situations of different courts where you have courts dilapidated, ceilings falling, and so on and so forth. But even in that space, the department's budget on infrastructure over the past 5 years has dropped, if I'm not mistaken, by more than 3 billion. And part of the problem why Treasury kept on targeting that part was because they will give you 5 billion. And at the end of the financial year, they still find that you have 3.5 billion available and said, but there's a problem here. You are not spending. We're going to reduce it. So they have been reducing. There's been a downward, trend in that area. Part of the reason is because as well, the same as CETA, the Giyama Act, which is administered by Public Works, requires that you go to Public Works. So even if you see a need to construct a court in a particular area and say, but we can run a process here, you have to go through the Department of Public Works. We all know the story of the Pretoria court just here in our backyard that got burnt down in 2010. The contractor has just only arrived now from 2010. Those stories back and forth between Public Works and Treasury. There was this contractor who then got removed. Another one came. So that's the story. I can speak frankly here because this is Parliament. This is the reality on infrastructure that we have to deal with. I'll come back in case I've left matters that I should have attended to. But maybe then generally on, I think it's Honorable Nomvala, on the oversight. And I think it helps us a great deal because when you're a Director General or Chief Master sitting in Pretoria, you can't be everywhere. And so my take has been, even to my colleagues in senior management, that when members of Parliament do oversight and raise matters with us, we should see it as a positive that helps us to know where the problems are. And our colleagues, masters, are here online as well, from all over the country. So that they must know from here that our expectation is that when a visit happens by any honorable member, announced or unannounced, it's their duty to take them around and account for anything that has happened. And that once we're informed that there was such a visit, will require an explanation ourselves as to why certain matters are being dealt with that way. Look, the issue of queues, we are not saying we've dealt with, but we're saying just the intervention that we've made has minimized it. And it is our desire as part of this turnaround to eliminate the queues, that people who come to our offices, as SARS will say, it must be out of absolute necessity. But those that, particularly people who come for trust, because those are people of means, poor people normally don't have trust per se. Those are people of means, they can do it electronically or from the comfort of their homes, that those who come, but also we are committed, and this is part of what we're trying to do as well, the change of attitude, that any member of society who comes to our offices, not only in masters, even in our courts, whether it's for child maintenance, domestic violence, protection orders, that we must, all of us as officials, have this empathy that it can't be that they come back, they get told, come back next week, and they come back next week because they come from, they have to spend whatever the last cents they have to come and seek services. It's not an easy issue, but we have prioritized this as well, Batupili and service delivery improvement. Acting Chief Master.
Thank you, DG. I have been requested to have a camera on. Chair, if I may request that my camera be on just for a few minutes, just to save on the bandwidth. Thank you. Just to respond on some of the questions, Honorable Breitenbach spoke about the trust follow-up signs or sign that was put up on the Cape Town Master's door. And I think the question was which stakeholders were engaged. In this instance, the big trust companies were engaged, ABSA, FNB, Standard Bank, the big four banks, as well as through the Banking Association of South Africa. We also engaged the Fiduciary Institute of South Africa, and I confirmed yesterday with the CEO of FISA, who confirmed that indeed the message was passed through the regional conference, that the action would be taken. How does this help the ordinary client? It does not, because the ordinary client would not have been part of the meeting. The ordinary client who might have a family trust that they need a follow-up on would not have been privy to those meetings. So we do acknowledge that our communication does need a bit of a polishing up, and we are going to engage together as the Masters team to work on a better communication method, especially in dealing with ordinary members of the public that may not be aware of the engagements that we hold with stakeholders. The other question that was asked by Honorable Breitenbach was on the suspension without pay of a specific individual. And this individual's or official's disciplinary hearing was commenced prior to the SIU's report being handed to us for a completely different matter. Now, we would have a chairperson in a disciplinary hearing who makes a determination based on the evidence that was presented, as well as mitigating and aggravating circumstances that would be presented. In this instance, he found the official guilty of the alleged misconduct, which was serious in nature. However, his sanction was that of a 3-month suspension without pay, in agreement with the DG, because of the seriousness of the transgression, as it relates to insolvency matters. We have resolved to take it on review, but there were additional charges that were then presented to us in the form of the SI report that were then preferred against the same individual. So he remains on suspension. He has not come back to work. I hope I've dealt with the questions. Honorable Nomvalo, regarding the RAF approach of decentralized staff, whether we would be able to have staff on the field. This is something that we would have to go back and engage on as the masters. As it is, we are constrained where capacity is concerned and assisted by the 207 Magistrates Court. But I do agree with you where you say a majority of the states are not reported because of ignorance. In fact, Stats SA report that only 30%, plus minus 30% of estates that are reportable are reported with the master of the High Court. And that is a serious issue that we are looking into. Such that we have embarked on a different program through the DG and members of EXCO, looking into the democratization of estates as well as wills, which will run from the month of November in the form of roundtables, where we look at people in the rural areas who have estates or who have property, but these are not titled properties, and that is for that reason that people do not report them with the master's office or do not feel the need to report them, as there is no proof of ownership. However, this leads to family feuds and other members being dispossessed of property because of the non-reporting, as well as the proper winding up of that estate. The other question from Honorable Nomvalo was regarding the turnaround time, that some cases take 1 day, some cases take several days, and that leads then to discomfort from members of the public. That is correct. There are cases that are quite simple in nature, medium complexity, and those that are very complex. Your simplistic cases in terms of turnaround time, you would see that our offices are averaging 11 only on online cases where there is visibility, 11.79 days, mostly assisted by Bisho, whose turnaround time is at 3 days, Johannesburg, Durban, and a few other of Bloemfontein, PE, and a few other offices whose turnaround time is much shorter. We do have longer turnaround times. We've had Cape Town with a big backlog, which resulted in their turnaround time being over 30 days, but they have reduced their backlog dramatically, where they had over 577 in the month of April. We are now speaking of just 132 cases in backlog. So we have improved there. In terms of the confirmation letters or the reluctance of masters to confirm letters of authority or being lethargic in confirming letters of authority with the banks, we no longer confirm letters of authority. The new letters of executorship or authority they come with a QR code or a quick response code embedded in the letters. And this quick response code allows banks, your life insurance companies, to scan the letter, which takes them directly into our deceased estates portal, where they verify first the authenticity of the letter. They then verify the appointments that the masters would have made in respect of that estate. So we no longer confirm letters of authority, and that has helped in alleviating the issue we had where external parties manipulated letters of authority, or you had what we call touters that would issue fraudulent letter of authority to members of the public without the master's involvement. And Honorable Matafa asked whether our system is interactive in the form of email, and the simple answer is yes. Our clients or applicants choose a preferred method of communication at registration, and it can only be by SMS or by email, where an email, now I think I'm just being informed, an email has been made mandatory. So if there is an email, then you do get an instant message that you need to go and amend your application, or a letter has been issued, which is also available on email or on SMS, whichever method that you chose. Honorable Mataf also asked how how does the online or how do our improvements respond to the Trust Property Control Act, and do we have capacity? With any amendment to legislation, there is a need to cost the new legislation in respect of the resources that would be expended in dealing with the added responsibilities. So I do agree there has been added responsibilities in respect of the requirements by the FATF, the requirements that are imposed by the Trust Property Control Act. How are we going to deal with it? At the moment, we have already completed the creation and development of the beneficial ownership through ICT. So that already has been completed. What remains a challenge is dealing with the submission of beneficial ownership. That requires staff, that requires masters officials to also review on a periodic basis where there is non-compliance. It is for this reason that we cannot obviously operate in that with inadequate capacity. We are going to go online such that trustees, trust companies would be able to do this on their own, and our job would be to review, which would have minimal impact on the staff in the master's offices. Is there any training intervention that are inward looking as opposed to the outward looking programs that we've presented? Yes. Through the Bridget Mabandla Justice College, there are master's programs that are part of the curriculum of the Justice College, and masters are trained periodically on those. What we have now resolved to engage on with the Justice College is on the softer skills in terms of customer care, in terms of etiquette, in terms of dealing with a mandatory fraud and corruption course for the masters, and that is still planned for this financial year. Appointment of insolvency practitioners, whether there is a deterrent, other deterrent besides the tip-off line. Yes, and the insolvency process is where we are members of our staff are most susceptible to bribery, corruption, and we are moving towards an online platform in this instance. And where it happens in the insolvency process is where we appoint practitioners to deal with insolvent estates. This is where there could be the, interference with the process, where practitioner may then approach a master's official to make an appointment in their favor. And to that instance, that is why we are moving to an online system where the appointment will be determined by the criteria that is in terms of the Act, in terms of our regulations as well, by value, by amount, as well as historically disadvantaged, based on our list in the manner that is part of our SOPs. Honorable Todetsi asked about the SIU report, whether there was any impact to ordinary people in terms of incorrect appointments. Honorable Todetsi, in the SIU report, there were additional 137 matters in which the SIU investigated, and their finding or outcome of those investigations was there was no maladministration found. I think it relates to a question I did not answer to Honorable Breitenbach to say, how do documents get lost? And you would see in the SIU report where a file would be misplaced, would get lost, and the SIU in just about 5 of the 137, they could not confirm the allegations because the files had been misplaced. And it is conceivable that the official may have misplaced or lost the file. That is not to say how files get lost. That is the only reason that files get lost. They get lost because as they change hands, between several officials in the masters, they then would be misplaced, and in the end, they do not reach the file room. I was in Johannesburg and in the master's office looking for a specific file where there had been a complaint, and lo and behold, that file was sitting on somebody's desk because there had been another inquiry on it. But in the file room, we could not find it anywhere. So some of the files where they get lost, we do then create a dummy file, which then prevents or does not disadvantage the client at all. Now, in terms of whether there's been incorrect appointments, one would say based on the SIU report, there are only 2 cases that relate to deceased estates, but not relating to incorrect appointments as such, but relating to where a master's official would have referred a client to an attorney or a legal practitioner who for some form of benefit in return. And are they specific for all the to specific offices, or is it for all offices? The 14 officials were in several masters' offices: Johannesburg, Pretoria, Polokwane, Bloemfontein, and yes, I think those were the offices. Honorable Dana asked whether we communicate with stakeholders. Yes, we have regular meetings with stakeholders on a monthly basis. Yesterday, we had our quarterly meeting with the Banking Association. The meeting convened by stakeholders on a monthly basis as in agreement with stakeholders is actually chaired by the chairperson of the Johannesburg Association of Attorneys at the moment, and the chairmanship is rotational. In the previous one, it was chaired by a member of SAICA, and all stakeholders are present in that meeting, with the exception of insolvency practitioners. We meet them separately in separate meetings, but we also part of the same communication group where issues are communicated to them, sometimes on a daily basis. The DG has dealt with infrastructure as well as the CETA or system issue. And I have then addressed Honorable Dana's question around the notice and the reasons on the Cape Town notice. Honorable Mkhwebane asked about incomplete applications. What is the Masters doing to follow up? The incomplete applications, before we rolled out the system, there has been discussion, and also based on best practice in terms of the probate systems that are available across the world. We give the client the opportunity to complete a registration. Often clients may not have some supporting documents, so they leave the application to come and complete it at a later stage. But what I can confirm, Honorable Mkhwebane, is the system does tell you which documents you would need to complete the application. Additionally, you would not be able to submit an application with missing requirements in terms of documents that need to support that application. So it is not yet, we do not classify it as backlog, because clients still need to go back. They may need to get, some are delayed by nominations by other next of kin who might be refusing to nominate someone as a beneficiary. But these are issues before they are ripe for the masters to deal with. We do see that sometimes it takes on average 5 days for someone to complete a case, and others have been languishing on the system for quite some time. Do we have a follow-up mechanism with clients? And not at this stage, because it is in the client's hands. However, based on your question, then it triggers one to say, do we need to send maybe communication to the 500 odd people and say you need to complete your application by X date? And I think we will definitely consider that as a solution in dealing with the incomplete cases. The service standards, yes, we do have service standards. Is the 15 days published No, currently it is something that is communicated to stakeholders. It is something that we use as a measure, but it is something that can be published in every master's office, as well as in every magistrate court that deals with master's matters. So we will take that proposal on board, where we would publish the turnaround time in respect of deceased estates, such that clients would know what is expected and what service they, and at what stage they should start inquiring. DGS has answered the issue on Nelspruit, the Lowveld and Highveld. I think the only issue that maybe remains on that question is it allowed for Mpumalanga people to register in Pretoria? The registration of deceased estates or the jurisdiction is determined by where the deceased lived 12 months prior to their death. However, there could be a waiver of jurisdiction that is prior to even registration, based on distance, based on other issues that could affect the applicants. There could be an application that is considered by master for a waiver of jurisdiction. And also there is a master's office in Middelburg that is servicing Witbank and surrounding, Middelburg, Witbank and surrounding areas at large. Is there a person responsible for complaints? Yes, we on our website, the master's website, the complaint, there is a protocol for complaints, Advocate Mkhwebane, that has been established for quite some time. However, we do realize with all our emails and contact details that are published that the protocol is not followed. The first port of call is the acting chief master is sent an email, or it gets to a member of the portfolio committee or the minister, and it gets passed on to us before the protocol is followed. However, this is something that we need to emphasize again, that we would like to give the office of jurisdiction the opportunity to rectify or remedy the issue of service where there had been a lackluster service or where there had been misunderstandings, that they get the first opportunity to satisfy the client and make sure that they deliver proper service. And in the event that there's not been any joy, that is when it is escalated into the office of the chief master through the assistant master in the office of the chief master responsible for complaints. And that person is Tebogo Tladi. She is responsible for all escalated matters into the office of the chief master. And the question that Advocate Mkhwebane also raised is about, what do you do with a person who's no longer happy with the executor of an estate, and the master asking them to report the person with the LPC? The master may remove, in terms of the act, an executor under certain conditions, and one of them being dishonesty, impropriety, or even by a court order. But what is most important for us is non-compliance with the master's directives. So we may remove an executor on that basis. So we are very much limited by the act in terms of when we can remove an executor. We have multiple cases where it is the person alleges or a client alleges that they do not want the executor anymore because the executor is friends with another of their siblings. That does not then qualify in terms of the requirements of a removal of an executor. However, where there is impropriety, we have assisted Advocate Mkhwebane in reporting legal practitioners to the LPC, the compliance division of the LPC, in dealing with the matter. And once they complete their investigations, we do get reports from the LPC, as well as when they struck any of the legal practitioners of the role, they then inform us, and we ensure that none of those practitioners are appointed as executors or in any estates. The issue of liquidators, inadequacies of checks and balances, how far are we with the policy? I think the DG has also responded to that. And how far are we with the recovery of the GF money? I think the DG has also responded to that. Are there any internal controls? Yes, we do have internal controls. After the breach of process in April 2023, a new process was implemented in which the master no longer gets involved in the actual processing of payment for the Guardians Fund. The Financial Management Services unit is now responsible, and there are control measures in terms of ICT, where we've in the back end, where there were issues in the back end, where details of beneficiaries could be changed, that we have put control measures in the back end of ICT. And with those control measures, we've averted 32 attempts just in the months of May and June. So is it fail-proof? At the moment, we are still comforted that there have not been further attempts in the back end from a back end perspective in the Guardians Fund. I think, Chair, let me pause here. I think I have answered all the questions. Thank you.
Thank you very much, Acting Chief Master. Can you brief us and what is the setup, turnaround times in finalization of matters? Just that alone.
Sorry, Chair, in the finalization of deceased estates.
Yes.
Okay, thank you. Once an application has been made, the turnaround times in terms of application for us to appoint either an executor or to appoint an administrator in terms of a Section 18.3, it's 15 days. So that is from application to an appointment. We then, if in terms of a letter of executorship, the estate is greater than 250,000, we will then, or there is a will, it is a testate estate, there is now then the time for the executor to advertise the estate and to finally lodge a liquidation and distribution account with the Master of the High Court. We allow a period of 6 months for the lodgement of the final account. However, that is solely dependent on the the executor of that estate. So there is an opportunity for them to ask for an extension. The master will assess the reasons for the request for extension, and if granted, then they would grant the extension. However, in terms of the Act and our policies, it is 6 months. Post the 6 months, the master then has to examine the account, and after examination of the account, it may be subject to an estate duty, which SARS would then need, within that 21 days where it lies for inspection, would need to come in and object to the account. Should they not object, the master would issue a notice of distribution to the executor, and the discharge. Once that is finally done, the executor would be discharged. So in essence, the process, depending on the complexity of an estate, some take 3 months, but in terms of depending on the speed of the executor in finalizing the estate, would take up to 9 months.
Okay, you say that is for the testate estate. Then what is the turnaround time for the intestate estate?
For intestate estates, the turnaround time is 15 days. Once we have issued an appointment letter, the master does not have oversight of the process when it's less than, we appoint and we give the letter of appointment and we close the matter. So it would be 15 days. Chair.
Thank you very much, Acting Chief Master. Members, that is the update, and that concludes the briefing by the Department of Justice on the interventions in the Master's Office. I think the conclusion would be really on matters relating to the fact that the committee must actually conduct oversight. You'll remember that the committee's program only ends on the third term of this financial year. So I think part of what we must do as will be developing a program for the fourth term. We'll then have to see to it that this kind of briefing and interventions are actually monitored and oversighted by the committee. We'll do that immediately as we develop a program for the fourth term. Or Nomvalo, I see your hand is up.
Yeah, thank you, Chair. No, just a quick one, Chair. I wanted to ask from the acting chief master that how do they deal with cases of a deceased who was in a customary marriage which was not registered? How do they deal with such inquiries? Or if they do make inquiries, by the way, do they refer people to the Home Affairs or to Home Affairs, I mean, or they do their internal inquiries? I want to get an insight on that. Thank you very much.
All right, thank you. DG, Acting Chief Master, quick, the unregistered customary marriages.
Thank you, Chair. This is one of the challenges that we have in finalizing deceased estates quicker. However, the master has discretion in terms of the Act to accept a document that purports to the validity of the marriage, which means a lobola letter could be accepted where there are witnesses to that. There is an affidavit could be accepted. The chief in a certain area could write a letter with a stamp attesting to the marriage that took place, and the master retains discretion. However, some of the letters that have been sent through to us have not been accepted due to the lack of witnesses that have come forward to have witnessed the marriages, or they may even look like a fraudulent letter, and the family cannot be contacted to validate the marriage. But we do look at other factors, and the masters have discretion to accept other documents other than a marriage certificate. Thank you, Chair.
Thank you very much, Acting Chief Master. DG, Acting Chief Master, we thank you very much for that concise presentation on the interventions. And we wish to say to you that we'll be doing oversight in relation to the Master's Office, solely because we want to take the spirit Honorable Brenbach was talking about, that the committee itself must play a supportive role for you to be able to achieve what you have presented as an intervention to the Master's Office. So thank you very much for coming to the committee to present this strategy. We'll take it as a working document where interventions from the committee are needed. We'll definitely avail ourselves to ensure that was the actual intention is that the Master's Office must be up to its work, and it must efficiently do what is expected by the people of South Africa for it to do. So thank you very much, DG. Thank you very much, Acting Chief Master. Now we'll take the content advisor. Of course, if you still have other commitments, you may be excused, DG and Acting Chief Master.
Thank you very much, Chair. We wanted to make that request, our indebtedness to you and the members.
Content advisor.
I'm here.
Can you brief the committee on the pending statutory appointments briefly? And please
Yes,
also that members are supposed to be traveling to attend the house sitting. So let's be considerate to that. You can proceed.
Yes, Chair, I'll be as quick as possible. So we're dealing with two appointments. Jabanani, that we can stay here for a moment. The first one is to fill the position of the Deputy Public Protector. And the second one is the Deputy Chairperson of the South African Human Rights Commission.
Sorry, Mrs. Yanda Nondabula. Please bear with us. You are disrupting the meeting. You can proceed.
Thank you, Chairperson. Benani, are we going to start with the Deputy Public Protector? Benani, can we go to the next slide? Okay. Here, the important thing to notice is the last bullet, in that in 2003, a section was added to the Public Protector Act to provide for the appointment by the President of a single Deputy Public Protector on the recommendation of the National Assembly. So you won't see the Deputy Public Protector position provided for in the Constitution. It is a statutory appointment. The next slide. Here, it's a very familiar appointment process. More or less, when a vacancy arises, the matter is referred to a committee, a multi-party committee of the National Assembly. The committee does its work and makes a recommendation to the House. The House will then debate the matter and resolve to make the appointment. The majority there is to make the recommendation to the President. Sorry, the majority that is needed there is a simple majority. There aren't any special voting requirements there. And then the President, on the recommendation of the National Assembly, shall appoint a DPP for a period as determined at the time of the appointment, but not more than 7 years. So the appointment can be up to 7 years. Next slide, Benani. No, and here I'm just saying, although the process to appoint the DPP is similar to that of the PP, there are important differences. So here again is that the appointment is found solely in the Public Protector Act, whereas the appointment of the Public Protector is provided for in the Constitution as well as in the Act. And unlike the Public Protector, the Deputy Public Protector is eligible to serve one additional term. Next slide. Then just to make a note around the powers of the Deputy Public Protector, the Public Protector provides that the Public Protector is responsible for delegating powers to the DPP. However, the PP Act provides that the DPP acts as the Public Protector if the Public Protector is unable to perform his or her, I should say, their functions, or while the position is vacant. The Public Protector Act also provides that the Public Protector is assisted by the Deputy Public Protector. So the position is very important. Next slide. These are the criteria for appointment. These are kind of what I like to call the minimum or the minimum qualifications as provided for in the Act. So the Deputy Public Protector must be a South African citizen. They must be a fit and proper person to hold the office and be a practicing advocate or attorney for at least 10 years. That can be cumulative, or have qualified to be admitted and lectured in law at a university for at least 10 years, so a legal academic, or have specialized knowledge or experience in the administration of justice, public administration, or public finance for at least 10 years, cumulative, or an MP for at least 10 years, or has any combination of experience mentioned above. Again, the requirement there is for at least 10 years, and that can be cumulative. Jumping to the South African Human Rights Commission, Bernard, you can go to the next slide. That just covers the its mandate. So here it's just important to note that the Commission has 8 commissioners, of which 6 are full-time and 2 are part-time appointments. Not part-time, yeah, they're part-time, sorry. At present, because of the resignation, there are 7 commissioners, of which, so there's 7 commissioners. The vacancy arises because of is a full-time appointment. So you can go to the next slide, Bonani. So as Commissioner Choan was appointed in a full-time capacity, the vacancy is for a full-time commissioner. I'm sorry about the spelling mistake there. Also, as Commissioner Choan was the deputy chairperson of the commission, there is also a need to be for the recommendation to be there also needs to be a recommendation about the position of the deputy chairperson. So in terms of constitutional criteria, it's section 193(1) of the Constitution, which provides that the commissioners must be South African citizens and fit and proper persons and comply with any other requirements prescribed by the national legislation. There's also a provision in the Constitution that provides that the Commission must broadly reflect the race and gender composition of South Africa. Next slide. Here, I just wanted to highlight that the actual South African Human Rights Commission Act highlights the need for independence and impartiality, and that really speaks to the character of the commissioner. Then the next slide, Bonani. The actual statutory criteria are that the person appointed as a commissioner must be a South African citizen. They must be a fit and proper person. Those are both the constitutional requirements. In addition, they must have a record of commitment to the promotion of respect for human rights and a culture of human rights, and be a person with applicable knowledge or experience regarding matters connected with the objects of the Commission. So those objects include promote, protect, and monitor the observance of human rights. The disqualifications, these are people who cannot or may not be appointed. So that would be your unrehabilitated insolvent, the person who's been declared of unsound mind, convicted of an offence and sentenced to more than 12 months of imprisonment without the option of a fine, an office bearer or staff member of a political party, member of the National Assembly, a permanent delegate of the NCP and MPL, a member of a municipal council, or who is on the candidate list for any of these positions, appointed by or in the service of the state, and receiving remuneration for that service. Again, the process is that the vacancy arises. The referral gets sent to the committee. It makes a recommendation to the House. The House will vote on it and make the recommendation to the President, who then must appoint on the recommendation of the National Assembly. The approval by the Assembly is by majority vote. Next slide. Here, in terms of the period of appointment, they are appointed for a period of not more than 7 years and are eligible for reappointment. In the case of a vacancy in the office of a full-time commissioner, the President may, on the recommendation of the House, appoint a part-time commissioner in the full-time commissioner's position for the unexpired portion of that part-time commissioner's term of office. So if we have a part-time commissioner who is appointed for 7 years and has served 2 years, and then they apply to be a full-time commissioner, then the appointment would be for the remainder of their initial appointment of 7 years. So that would be 5 years. Next slide. Okay, again, I mentioned this. The President must appoint a chairperson and must appoint the chairperson and deputy chairperson of the Commission on the recommendation of the National Assembly. So we'll need to, when we make our recommendations, consider that as well. Just a little bit about, sorry, just quickly. No, it's fine. We can go on to this. In terms of the committee process, we have the referral which has been made. Our next step is to advertise the positions with a closing date. Once we receive all of those CVs, they get published on Parliament's website for public comment. We need to note that certain public personal information is redacted. The issue to consider is the time that's allocated for the public to comment and how to address any negative comments received. The shortlisting issue to consider here is a declaration that there's no conflict of interest by members, and then how many would we shortlist? Yeah, I mean that would depend probably on the number of applications we get, and then also the number of positions that we're filling. In terms of the questionnaire, we ask our candidates to fill in a questionnaire, and the question is then, should that questionnaire be sent to all candidates or to those shortlisted? We have in the past Parliament sent only to those that have been shortlisted. Screening, the issue to consider is the time frames. This process takes a little bit of time, so that needs to be factored into our process. And then the other problem is how to address any potentially damaging or embarrassing information that is received with sensitivity. And then in terms of the interviews, then the issues to consider is when will that happen, the length, the questions asked, the process that the committee would like to follow during the interviews. And then the final step will be the decision and the report that is sent to the House. Thank you.
Thank you very much, Content Advisor. Members, I think it will be important for us to agree in this meeting that this week we must issue out advertisement for both the Deputy Chairperson of the Commission and the Deputy Public Protector. Members, any quick indications to that, Honorable Bredenbach?
Thanks, Chair, and again, good morning to everybody. Chair, you'll remember that this matter has a bit of a history in the committee, and I'd like to know how we plan to deal with it. Thank you.
Thank you. I think Honorable Bredenbach was the only one. You recall, members, that in the 6th Parliament, there has been a deferral of this matter of the Public Protector on the basis of what occurred in the interviews in the 6th Parliament. But of course, we must agree that we must avoid such kind of issues for this particular process. Of course, we don't know who now will apply and if there would be a potential conflict and stuff. We cannot know at this stage until we know who has actually applied or who has actually been nominated. But I think our posture must be that we must avoid such kinds of occurrences again for this particular time. Honorable Mkhwebana, I see your hand is up. Honorable Mkhwebana.
Oh, Chairperson. Yes, I wanted to raise exactly that after the posts have been advertised and the support staff have compiled all the list of the applicants, and then when we do the shortlisting, I propose that there be a simple form which we will have to complete and declare. Auditor General can help us with that, or I can help as well with a simpler form where you indicate you know which candidate you are not aware of, and then that will help to declare at an early stage. And still, the legal advisor of Parliament who lied to the committee that she never worked at the Public Protector Office, I would request that she be called to account and clarify that, because she was asked and she denied that she worked at the Public Protector Office. by the member of the DA last 6th term. Thank you.
Thank you, Honorable Mkhwebana. Your proposal is artistic, that we must be able to receive the entire master list to declare as members. Ms. Silverstone, I'm sure you have noted that there must be a form that must be developed so that we avoid what would have happened in the last administration. Thank you very much, Ms. Silverstone. Please attend to the declaration letter. I haven't seen any question, so I don't think it will be necessary for any further responses for now. Members, do we therefore agree that this week advertisements must be out?
Yes, Chair.
Thank you very much. Let's go to Committee Secretary. The draft notices determining the salaries of judges, magistrates, public protector South Africa, and the Human Rights Commission. Can you flight them? Okay, that's it, members. The heading reads, what we'll do, we'll go paragraph by paragraph. Then members will just raise their hands if they want to raise something pertaining a paragraph. So it's a report of the Portfolio Committee on Justice and Constitutional Development on the draft notice and schedule determining the rate with effect from 1st April 2023, at which salaries, allowances, and benefits are payable to Constitutional Court judges and other judges annually for approval by Parliament in terms of Section 2, subsection 4 of the Judges' Remuneration and Conditions of Employment Act 2001, Act number 47 of 2001, dated 11 September 2024. You can go up. Any issues on paragraph 1 and paragraph 2? Can go up. Any issues on paragraph 3? Can go up. Is that the last paragraph, Committee Secretary?
Yes, Chair, that's the last paragraph.
Okay, thank you, members. Can I move for the adoption of the report?
Matafa moves, Chair.
Thank you, Honorable Matafa moves. Any seconder? Members,
Okay.
Honorable Dana, seconds and objections? No. Can you get a second report, Committee Secretary? Oh, damn it. I forgot to unmute. There is the topic. Members, can you go to the first paragraph? Second paragraph. The third paragraph. Paragraph 4. There is the report, members. Can you move for adoption?
Chairperson,
Honorable Mkhwebana.
I've got just a clarity. Didn't we discuss a 4.7% for magistrates? That's the first clarity I wanted to ask. Secondly, okay, then I'll come back to whether we
Okay.
have any reservations, yes.
I think 4.7 was for 2024 or 2025. Committee Secretary?
Yes, Chair, you're correct. We're still dealing with the 2023 one, yeah.
Yes. So that 4.7 is still coming out of Mkweba. Mkweba are still there?
Yes, thank you, Chairperson. That is noted. Thank you so much.
Sure. Can we move for adoption?
Honorable Tsotetsi, I move to adopt, Chair.
Thank you, Honorable Tsotetsi. Any seconders?
Matafa seconds, Chair.
Honorable Matafa, any objections? No, thank you. The report is duly adopted. Committee Secretary, can we get another report? Report on portfolio Committee on Justice and Constitutional Development of the draft notice and schedule determining the rate with effect from 1 April 2024 to salaries, allowances, and benefits are payable to magistrate annually for approval by Parliament in terms of what. This is the actual 4.7 now.
Okay.
Can you go to the first paragraph? One paragraph, paragraph 3. Paragraph 4. There is the report. Can we move for adoption?
I move, Chair, Matafa.
Thank you, Honorable Matafa. Any seconder?
I second, Chair, with the qualifier.
Okay, you can proceed.
I don't know how, but I think we'll discuss it when we present it. Still concerned about IRC, Chair, the delay and the way they deal with the failure for the past 10 years to do a review on the roles of magistrates. Thanks.
Okay, that's noted, Honorable Kwebana. Thank you for seconding. No objections? No objections. Committee Secretary, can you take the third one? Report of the Portfolio Committee on Justice and Constitutional Development on the draft notice and schedule determining the rate with effect from 1 April 2024 at which salaries and allowances are payable to the public protector and deputy public protector annually. Can you go to the first paragraph? The one paragraph. Your scrolling up is slow. Third paragraph. Proceed. Fourth paragraph. Fifth paragraph. Sixth paragraph. Seventh paragraph. Eighth paragraph. That is the report on PPSA. Can we move for adoption? Members?
Matafa moves, Chair.
You got Matafa, any seconder? Any seconder, members?
I'll second, Chair.
Thank you, Honorable President Park. Any objections? No objections. Committee Secretary, report has been duly adopted. Can we move to another report? Report of the Portfolio Committee on Justice and Constitutional Development of draft notice and schedule determining the rate with effect from 1 April 2023. Salaries and allowances are payable to the. Can you take this first paragraph, Committee Secretary? Second paragraph, paragraph 3. Yes, scroll up. Four, 5, 6, 8. That is the report, members, and adoptions. Members, can we move for the adoption of the reports?
Chair, I'll move.
Thank you, Honorable Klopa. And seconders?
Matafa seconds, Chair.
Matafa, no objections? No objections. The report is duly adopted. Committee Secretary, can you go to another report? A report of the Portfolio Committee on Justice and Constitutional Development on the draft notice and schedule determining the rate with effect from 1st April 2023 at which salaries and allowances are payable to commissioners of the South African Human Rights Commission annually for approval in Parliament. Can you go to the first paragraph? The second paragraph. Paragraph 3. 4, 5, 6, and 7. Paragraph 8. There is a report, members. Can you move for adoption?
Matafa moves, Chair.
You are Matafa, any seconders?
Chair, Klopa will move. Second.
Honorable Klopa, seconds and objections? No objections. The report is duly adopted. Thank you very much, members. Committee Secretary, do you still have a remaining report? Report of the Portfolio Committee on Justice and Constitutional Development on the draft notice and schedule determining the rate with effect from 1 April 2024. To salaries and allowances are payable to the Commissioner of the South African Human Rights Commission annually for approval in terms of Section 9, subsection 1 of the Commission's. Can we move to the first paragraph? That's the first paragraph. Second paragraph. Paragraph 3, paragraph 4. Paragraph 5. Paragraph 6 and 7. Paragraph 8. Members, that is a report. Can you move for adoption?
Matafa moves, Chair.
Matafa, any seconder? Any seconder?
Klopa will second.
Thank you, Honorable Klopa. Any objections? No objections. The report is duly adopted. Was that the last report, Committee Secretary?
That's correct, Chair.
Thank you very much, members. Thank you very much for patience on dealing with matters today. We have concluded all of them. Now the meeting is officially adjourned to allow you members as well to make it to Parliament for the House sitting. Thank you very much, members. Thank you very much to the support staff. The meeting is adjourned.
Thank you, Chair.
Thank you, Chair. Bye-bye.
Thank you, Chair. Sure.
Recording stopped.